A man who was acquitted in the death of an Indigenous woman will be heading back to court. The Supreme Court orders a new trial for Bradley Barton. He will be tried for manslaughter in the death of Cindy Gladue, who was a sex worker. Just a warning as well to some of our viewers. The details of this case, you might find some of them disturbing. Gladue was found dead in a hotel bathroom in Edmonton 8 years ago. Barton had paid her for sex, and he described their sexual activity that night as rough but consensual. He was acquitted of first-degree murder. The case caused public outrage over how the Indigenous victim was treated by Canada's criminal justice system. Here's some of the reaction following the court's decision.
There's no good answer here. Cindy Gladue's mother and her daughters and her family are going to have to go through this horrific trial all over again. That's not a happy result for anybody, but in terms of the injustices that happen below, the fact that the justice system will attempt to correct, that's a good thing, but there's no really good answer here. This horror show continues.
I think it's a step forward that the court has recognized that in cases of sexual assaults involving Indigenous women and girls, that there's an obligation on courts, on judges, to be gatekeepers, to ensure that bias, prejudice, racism, and sexism do not form part of the evidence, are not what juries and judges rely on to make their decisions. This is a big step forward.
CBC's David Cochran is following the case in Ottawa. He has more on the reasons behind the decision.
Yeah, so Hannah, you heard the split reaction there from the people responding to this decision. Well, it was a split decision. In fact, a 4-3 decision with the majority ordering a new trial for manslaughter. Now, the dissenting minority agreed with the decision to send this back to a new trial, but they also wanted Bradley Barton to potentially face charges for murder. The majority disagreed, so he's going back simply for a manslaughter retrial. Now, the reasons for this are because of errors made by the judge at the original trial. The first and most significant, arguably, being that he allowed the past sexual history of Cindy Gladue to be entered as evidence in this case without holding a hearing to determine whether that evidence was relevant or whether it could potentially be prejudicial, which was a blatant violation of Canada's rape shield laws, which is to protect the victim of an alleged sexual assault from having their past sexual history potentially used against them. The decision to allow this to go in without any kind of a hearing, in the Supreme Court's words, meant the jury was left adrift in a sea of dangerous and impermissible inferences. So that was the first major error by the judge. The second were bad instructions to the jury, particularly when it comes to consent. Bradley Barton and Cindy Gladue met for sex 2 nights in a row. Bradley Barton paid her for sex both of those nights, but simply because consent was given on night 1 does not mean consent was given on night 2. The jury was not properly instructed on this. The justices made the point that consent must be specifically renewed and communicated for each sexual act. They also found there was bad instructions given on what Bradley Barton's motive might have been and some of his after-the-fact conduct, where he gave very conflicting stories about what actually happened in that Edmonton hotel room that night. So based on those errors by the judge to allow this evidence to be heard about Cindy Gladue's past sexual history and improper instructions to the jury, at minimum, it's going back to a retrial on manslaughter.
And they did issue some guidelines on trial judges and how to deal with cases involving Indigenous women and girls in particular. Can you take me through some of those, David?
Yeah, that's been a real flashpoint in this case, and one of the broader public conversations that has come out of this acquittal and the way this trial was conducted. It wasn't dealt with specifically as a point of law in ordering the retrial, but because throughout the course of the trial, Cindy Gladue was referred to as a Native woman or a Native girl or a Native prostitute dozens of times, and the Supreme Court has found that, look, jurors carry their prejudices into the jury box, and it's up to the judge to give them proper guidelines on how to deal with cases where the victims are Indigenous women and girls. So they write that our criminal justice system should take reasonable steps to address systemic biases, prejudices, and stereotypes against Indigenous persons, and in particular, Indigenous women and sex workers. Turning a blind eye to these biases is not the answer. As an additional safeguard going forward in sexual assault cases where the complainant is an Indigenous woman or girl, trial judges will be well advised to provide an express instruction aimed at countering prejudices against Indigenous women and girls. So this is a new guideline to trial judges across the country from the Supreme Court to weigh all of these factors when instructing their jury to ensure that a fair consideration of the facts is given despite existing cultural stereotypes against Indigenous women and girls, in particular Indigenous women and girls who may work in the sex trade.